very fortunate to gather tonight to hear Professor Beecham talk about a topic which I know that many of you are familiar about from the time when he came to us in 2011 and his work in this field. But this book, Invented by Law, really addresses the topic that many people feel relates to the most momentous patent, the most momentous invention in U.S. history. But this book is a remarkable combination of impressive scholarship, original thinking about takes on the law and our legal history, and also it's a good read. It's very, very engaging. It's every bit as engaging and readable as Professor Poser's Lord Mansfield volume, which we, about this time last year, had a lot of fun talking about. It's yet another example of our faculty's true distinction as a world-class faculty. And without any further delay, I'm very, very happy to introduce you to our colleague, our friend, and our newly minted author who's already at work on his second book about technology litigation, right? Professor Beecham.
Thank you, Nick, and thank you everyone for coming out and digging yourselves out of the snow. I'm just going to say a couple of words about the book. Before that, I have a couple of people I need to thank. One, I'm not sure if he's here, is Josh Greenberg of our class of 2016, who did amazing work in the very last stages of the book, site checking and editing the final manuscript. The other is Anisha Dasgupta, my wife, who's on her way here, who really deserves, when you see her, you can tell her this, she deserves to celebrate the release of this book more than anybody else, very much including me. I'm not going to talk for long because the dean is waiting to interrogate me, and I'm expecting the Army McCarthy hearings. Have you no decency, Beecham? So
That's
I'm
my
not going to
line.
read. Be tough. I'm not going to read anything from the book. I'm just going to say a few words about where it came from, and then maybe sort of draw a couple of stories or vignettes out of it, just to give you a taste of what's in there. So I'll say a word about where it came from. Like many life-consuming, years-long projects, it started out with a really simple and probably pretty naive question, which was, why did Bell win his patent cases? You've got one of America's most famous inventors here, one of America's most famous inventors, whose fame seems to have a lot to do with his patent. The Supreme Court picked him from among all the other people who claimed to have invented the telephone, picked him out as the one inventor, and that wasn't nothing at the time because the whole fate of the early telephone industry depended on it, right? Control of the whole technology. So why did Bell win, I wondered. And I found this was a question that had escaped an answer. And more importantly, not just that particular case had escaped an answer, but it was really like lawyers were missing from the history of invention generally. So historians of technology, biographers of big-time inventions, the Smithsonian, they really had nothing to say about patent law. Patent law, and especially patent cases, were a black box. You know what comes out the end, but you have no idea how it works on the inside. So why did Bell win? I think I'll have to figure it out myself. And so we'll start with some basics. How much patent litigation was there in the 19th century? Where did it take place? What was patent law like? And again, I found this was a really unplowed field. This is kind of, it turned out, a forgotten branch of American history, even in the federal courts where it was so important. And the more people I asked, so what was patent law like in American legal history? The more said, I don't know, but that's a really interesting question. It just so happened that I was thinking about these things at a time when patent law was sort of coming back in public consciousness. It's really blowing up in American law and policy in the last few years. And lots of policymakers and lawyers, maybe especially the Supreme Court, are thinking about the history, wondering about the old case law, the traditions, the development of the institutions that got us where we are today. And the Bell story, the Bell patent, turns out to be a great window into this world. a sort of window into a forgotten history of American patent law, and a time when, to put things in perspective now, patent law was even more important and even more controversial and even more public than it is today. Okay, so like I said, I'm not going to try and digest the book. I'm not even sure if I can. I'm probably the person least best placed to do that. So I'm going to pull out 3 scenes or 3 pictures, 3 stories from it. The first one, which we should love, is all about the importance of listening to your lawyer. So it's also a reminder that patents, even when they're issued, even when they're fixed and the text is written down, are not entirely predictable or fixed things. So the night before the first big Bell patent trial,
Chauncey Smith.
Chauncey Smith, who should be your hero. They're going head-to-head with Western Union, one of the biggest companies in the country, the telegraph monopoly, the telegraph giant. And the night before, Bell is having this pitched battle with his lawyers over what his patent actually says. He's got his own theory about what's in it. The lawyers have their theory about what's in it. And he writes to his wife about how miserable it is to deal with these people who don't understand his invention. He says, they have plucked out the heart of the invention and they've thrown it away. He says, they've left it in the gutter. He says, my poor patent. But they browbeat him all night. And in the end, he gives in. He lets them go with their theory of what the Bell patent says. And that's the key to the entire making of the Bell monopoly. It's that theory, that claim they want to emphasize that is able to cover all telephone technology, that creates the Bell company's monopoly over telephone technology. His idea, whatever he thought, wouldn't have flown in court in the same way. So the crucial lesson is there, listen to your lawyer, right? I tell this to all my students. I tell this to all the patentees I meet. But it's also why I often say it was the lawyers as much as anyone else who invented the telephone, if you see what I mean. That's one story. Second story is about Bell at the Supreme Court, because I think that's the best way to understand in microcosm what the Bell telephone fights meant to the country at the time. So the arguments at the Supreme Court took place in January 1887, and the court blocked out 2 solid weeks for argument, which was a lot even then. It's a lot now. The lawyers in the case included US senators, former presidential candidates. There was one lawyer on each side who had declined a Supreme Court seat in the last few years. And the air of scandal was heavy about the case. The New York Times wrote editorials condemning Bell's fraud. One of the justices, Horace Gray, had to recuse himself after these tabloid newspaper headlines about a conflict of interest that he had been hiding all the way through the litigation, and he'd sat in one of the earlier cases. Even as the Supreme Court sat in the telephone appeals, the US government was suing to cancel Bell's patent for fraud in the patent office, and there's a whole story that goes with that. Then after these 2 weeks of arguments and these sensational daily headlines, it took a year for the case to be decided. When it was finally decided, it was 4-3, with one justice dead and one recused. I should have brought it with me. It's the only Supreme Court opinion that takes up an entire volume of the US reports. It is 126 US 1. It's the whole thing. When he completed it, Justice Waite took to his bed with exhaustion, a touch of pneumonia. Within 4 days, he was dead.
It's a great book.
I know you have felt. Did you read the record? When the lawyers, the great members of the bar, gathered for his memorial, they talked about the great cases of his career. They talked about Munn versus Illinois, the Granger case. They talked about the civil rights cases, the legal end of Reconstruction, and they talked about the telephone cases. That was the highlights of Morris and Waite. Now, when the Bell case was decided 4-3, it was Bell against this obscure Pennsylvania inventor called Daniel Drawbaugh. Nobody's heard of him now. Not clear that anyone believed him then. It was just a really good way to get at the monopoly. All of this, the politicians, the pretenders, the claimants, the publicity, it all sounds more like politics, maybe more like theater than like patent law. But that's really the whole point, right? This is the drama of 19th century patent law. You can see the conflicts of the day in which patent law was inextricably caught up. Monopoly against the common man, corruption against clean government, government against monopoly, the corporation and its role. All these things were in play in these dramatic cases. Okay, one last story, just in case you were thinking the telephone cases were a one-off, an impossible to repeat tale. There's a painting a painting called Men of Progress from 1862, which now hangs in the National Portrait Gallery in the center of Washington, D.C., in a building that used to be the Patent Office. So exactly halfway between the White House and Capitol Hill, in what was one of D.C.'s biggest buildings in the 19th century, a great temple of invention, nobody at the time would have missed the fact that patent law was central to the federal government, because it's right there in the middle of the federal city. And this painting shows the great inventors of America up to that day, so everyone before the Civil War. And if you go through them one by one, most of them had great patent campaigns to their name. They're people whose names had been made, not least, by their victories in court. Samuel Morse, Samuel Colt, Charles Goodyear, and so on and so on and so on. So that's why I think we can generalize from the Bell example. The Bell example is a great story, and I think it's the most gripping of these, but it's also something about the American patent system and American history more generally. Patents have done more than anything else to select and celebrate our heroes of invention, and behind every great patent are the lawyers. So that's what I'm trying to say. Okay, now I will expose myself to ridicule.
The telegraph, not the telephone, marked the birth of electronic communications. The telegraph was the first time in mankind's history where it was possible to communicate faster than the speed of sound and over greater distances with some reliability. The first words spoken, the first words in the first message in the United States on a telegraph from Baltimore to Washington, D.C. were, "What hath God wrought?" These are words that reflect a, in the moment, sense of the magnitude of what had been done, some foreboding even, and a sense of importance. That was 1846, I think. So by 1876, the first voice message communicated on the telephone that Bell used the first words were, "Watson, come here. I want to see you." Kind of reflecting that just in a relatively short period of time, the magic and awe of electronic communications had somewhat become blasé. And, it's when you think about it, it's kind of as if, Neil Armstrong stepped on the moon and kind of said, "Oi, that first step was a doozy." Or, softer than I thought. And so do those very words, they suggest that the telephone was more of an evolutionary enhancement of the original invention, rather, a creep rather than a jerk, in your words. To what do you attribute the widely held view that the telephone is such a momentous invention and that it's much more important in history than the telegraph?
So I think it's the lawyers. The difference between the statements, the "what hath God wrought" and the more mundane "Watson, come here," that's the difference between scripted remarks and unscripted. So Morse's is part
Good
of a
answer.
demonstration in the Supreme Court chamber in the U.S. Capitol that was meant to sell the telegraph to the U.S. government. So this was public display. "Watson, come here, I want to see you" is something that nobody knew about at the time. Tellingly, it actually came out in the litigation because Bell had to describe from his lab notebooks what they'd been doing at the moment of the invention. But the reason why we remember the invention of the telephone more than any other inventor for one thing is really about the lawyers, right? So their achievement is to tell a story in which the telephone is one dramatic new invention created by one person at one moment in history, and they tell that to support a broad reading of the patent. And the way they succeed also matters because off this, the telephone patent monopoly is built. That's the company that later becomes AT&T, the Bell system, which is the biggest corporate organization in America and the world for much of the 20th century, and which understandably pushes Bell in its propaganda and its publicity. So the lawyer's victory is sort of the thing that makes the big difference to historical memory. But both of those things, the idea that there's one inventor and the creation of the monopoly, are things that could totally have gone the other way. That's the interesting thing. So we might have had the idea that the telephone had many fathers, which is what they thought in Britain and in Germany. We might have just thought this was an improved kind of telegraph, which is pretty much what Bell thought. So his patent is called Improvement in Telegraphs, and it doesn't mention the word telephone anywhere. That doesn't happen in the first patent. If Western Union had been a bit more savvy, it could have crushed the Bell Telephone Company in the first few months, and then all we'd remember is the 1870s. That's when Western Union started to adopt voice communication.
All right, so let me jump in there and follow up what your comments are. Two questions.
Mm-hmm.
Who invented the telephone, and what is the telephone? And are those simple questions, are they factual questions, scientific questions, metaphysical questions, legal questions?
Yes, they're legal questions and cultural questions. Only when you decide what the question is do you know what the answer could be. And you could pick any number of different answers, right? If the inventor of the telephone is the first person to make a device that could be used to transmit voices, whether they've done so or not, then that's a different guy. If it's the first person to make a commercially valuable telephone that people would want to pay money to have in their homes, that's a different guy. If it's the first person to transmit a voice message over the wires, that could well be Bell. But that's only once you've defined the invention, who invented the telephone, a different way. And you don't need to think of the telephone as just one thing, right? It's got at least a transmitter and a receiver. In Britain, they always thought Bell was the inventor of the telephone receiver, right? Other people had done the other bits, Thomas Edison and other people. So defining the question is the key bit of deciding who invented the telephone, who was the inventor, and it was the lawyers and the patent law generally that decided the question, defined the question.
Okay. So that also raises another sort of series of related questions. Was it inevitable that patent law and our approach to inventions develop in the same way that they did in the United States? And why are patents more important in some countries like America and England than they are, say, in European countries like France and Germany? Why is that?
So some of it's just sort of really big picture what law means to America, right? It's a truism that we fight our big political and business and social questions through the courts in the ways that other countries don't, because of having, among other things, a strong tradition of individual rights or property rights, a relatively independent and powerful judiciary, right? Things go into court in this country that in other countries are settled by governments, bureaucracies, informal norms, big banks getting together to figure out everything among themselves. That's what happens, if you want to pick an example, with the telephone in these other European countries, right? It gets nationalized very quickly. The decision makers who decide what form the industry is going to take are not courts, not lawyers.
It's the government.
It's the government, yeah. Even in countries that had patent systems, Germany gets a patent system. This is not a coincidence. So the guy who is the moving force for Germany's imperial patent law is Charles Siemens, who himself is an important telephone inventor. And that comes in 1877, just too late for Bell. So Siemens is there saying, I'm so sorry, Alec, you can't get a patent. We've already started selling your telephone before we got the patent law. So there are sort of idiosyncratic reasons in some countries, but mostly it's just in America, the patent system has been big and very accessible and very plugged into the judicial system and property rights in a way that in other countries it's been more of a sort of government policy to subsidize.
But it was right from the start. So if you go into the Library of Congress, you talk about the architecture in Washington. If you go into the Library of Congress in the Jefferson Building, and you go into the rotunda and you stare up, I'm not going to have eye contact with our librarian, Janet Cinder, because I'll probably say something slightly off and she'll correct me. But you look up, there's a painting in the rotunda, and in that painting, they have these major figures, icons of American history. And Thomas Jefferson is sitting on a tree stump, holding in one hand letters patent, And then those little models of the inventions which he authorized as Commissioner of Patents, which he felt was his highest public office. So why is that the case? Why have patents been so important from the beginning?
Thomas Jefferson couldn't wait to get out from under it. He was Secretary of State, so he had to sign all the patents.
Too many cases. Huh?
Yeah, it's just too many patents. So in the end, he said, let's change the law. So they changed the patent statute, so it wouldn't be his problem anymore. You didn't have to examine them, you just had to sign them, and that was it. But
A registration system.
just a registration system, yeah. But it goes back all the way to the Constitution, Article 1, Section 8, Clause 8, empowering Congress to create laws to protect inventors' exclusive rights. Really
Why?
starting at-
Why? Where did that come from?
Well, in the beginning of the country, there's obviously people, including Madison and other founding fathers, who thought we need to get industry very quickly, otherwise we're going to be steamrolled by the European powers whenever they turn their attention back to us, right? So this was a project of national growth and strength and ultimately national survival, where
To
the
be
key thing-
independent.
to be independent, yeah, to survive in a new country hanging precariously to the eastern seaboard of the North American continent. And how do you get industry? One way to do it is to have a functioning patent system. Another way is to steal skilled workmen from England, which actually worked better at the beginning. But having a functioning patent system...
Did I detect a bias from your accent?
No, I'm as American as you.
Okay.
Seriously? No, it's an excellent book about America's rise of industrial rise and the extent to which it worked, like every country's industrial rise, based on piracy of industrial secrets from the next country up. So the British stole from the Dutch, the Americans stole from the British.
Everybody
China
stole
into
from the
that as
French,
they see fit.
right?
Anyway, yeah, so right from the beginning, there were all sorts of aspirations attached to the patent system. And then, really, America creates the first modern patent system with a patent office, with a rational bureaucratic system where you get applications examined. It's the model for what the rest of the world ended up following a half century or a century later. And it's proven, as an institution, enormously successful if you define success as growing and being a model for everyone else.
And then right as the law was changed in the middle of the 18th century, that cathedral to patents burned to the ground.
Oh, the old one burned. So in 1836, all the patents they collected, all the models, they were all shoved into the General Post Office for safekeeping while they built the new patent office, the great sort of Greco-Roman temple in the middle of DC. And while they were there, they all burned. So we lost
Oh, I
a
see.
lot of our patent heritage.
So we
It
talk
makes
ab-
a nice
yeah.
dramatic switch.
A nice, right, a nice transition, clean sweep,
Has good narrative value.
I noticed. So we talked about why, from the start, patents were important in the United States and part of the Constitution. Why are patents in the United States more important for some businesses in contrast to others? Railroad versus electric
Right.
communications.
It's very much like the line about guns. Right? Patents do not cause patent litigation, people do. So what a patent means and which institutions and which industries patents are important in depends entirely on the kind of structure and the strategy of those businesses. A patent is not, as many people might think, just corresponding to an invention. A patent is a strategy about how to get money back for some particular kind of investment in invention. So in industries where you get big companies that compete on other stuff, compete on model or quality or price, don't compete on technology, patents often get sidelined. So the railroads in the 19th century, their competition was politics and line building and regulation, but they didn't want to compete with each other on technology, so they made sure they cross-licensed all their patents, they formed big patent pools. If any inventors came to them, the railroads would band together and try and stamp it out. Same with the automobile industry in the 20th century. GM and Ford didn't compete based on, we've got a whole new technology. They had other grounds for competition, so famously your patents in the car industry weren't worth very much. But then you get patents on the sort of electrical technologies, or now in software and biotech, where companies want to compete on the basis of what technology they've got and want to make some attempt to capture a particular market. And their patent competition is ferocious, and they'll all sue each other. So it's really about the companies, not the law, not the inventors.
So you point out that while Jefferson and others were complaining about the volume in the early days of patent applications, you point out that between the end of the Civil War and 1900, there were something like 600,000 patent applications, or was it patents issued? I think patent applications,
Right, yeah.
which is 10 times greater than the amount filed in the previous 75 years before the Civil War. So 10 times as many. So why was this explosion? Why were there so many? Was it because we were getting smarter? Was the country growing that fast? What was that all about?
It's a lot of things. I mean, the country growing fast is really part of it. That's a period when the US population goes from something like 30 million to 75 million in 40 years. It's almost unbelievable what the country was like in that period, just in terms of growth, crash urbanization, crash industrialization. It was transforming at an incredible rate. So part of it is just the industrialization of the country compared to what it had been before the Civil War, westward expansion and all the rest of it. Part of it is the so-called Second Industrial Revolution, right? So all these new scientifically based industries, pharmaceuticals, electrical, chemical, things that sort of made a business of invention and had R&D labs for the first time. That's part of it. And part of it, which is not irrelevant to today, is gold rush mentality, right? This is a period where people could see how important patents were in the industrial economy. You could see that you could patent something and get rich quick. And that's not irrelevant to having people think, I'll spend it wasn't very much, $35, about $600 in today's money to get a patent and to stake my speculative claim.
Was it $300 at the start of?
No, it's always been 30 or 35 in
30,
the US,
35,
except
okay.
for the English. Because
For them it was more?
yeah, so for foreigners, to start with the foreigners, you had to pay to get an American patent what an American would have to pay in your country. It was designed to be reciprocal. So the English patent system was always expensive and bad, generally to be condemned.
So your slender, insightful, very readable volume is only the visible part of a huge mountainous iceberg, and it sits on top of a lot of research. Talk a little bit about your research. I mean, what techniques, how you went about it. I mean, we're talking about the volume of cases, but there's a huge amount of work, and I'm assuming that you were actually going to some of the courthouses or having people do that. Talk about your research.
I wasn't having people do that. I'd love to have people do it, but yeah, it's only...
Your people, something I get to do.
So a lot of the research was defined by what I couldn't do. So early in the project, I thought I'd spend a lot of time in the AT&T archives, which basically because there'd been so much antitrust litigation against AT&T, were the best organized corporate archives in the whole United States. I thought they were at 125 Broadway in this glorious setting. And so I thought it'd all be inside. I'd learned the story of the patents from the inside. When I arrived, firstly, they moved out to a storage facility in North Plainfield, New Jersey, which was kind of sad. And secondly, they closed. So I couldn't get anything. I was allowed to go there for a week, but not have access to
What do you mean they closed?
They closed. They were jointly administered by AT&T and Lucent, who decided it was very expensive, so they wouldn't let outside researchers come in anymore. So that turned out to be a good thing. It was sad at the time, but it was a good thing ultimately because it sent me looking out to what I thought would be the periphery, looking at publicly available sources, the press, things in all sorts of other places, but which taught me just what the scope of the Bell patent story was. If I'd sat inside AT&T, I would have gotten the view from the patent drafting, maybe. Who knows what's in there? They still haven't let me back in. But on the outside, I could see how public this story was. You could see it in the press. You could see it in the journals of the time. You can go and read the diaries of Supreme Court justices. I could read the family correspondence of Alexander Graham Bell and his wife and his parents-in-law. Thomas Edison, whose papers are all very well curated at Rutgers and who turns out to be surrounded by extremely candid, very rude people. You can get in the archives and read thousands of personal stories from across the country, all of which fed into the telephone patent story. You've got to be nosy to be a historian, so it's wonderful to get inside people's private stuff. And you've also got to let the
We lived on the
sources
same
know
floor.
where
Are
they
you nosy?
No.
Okay.
No. Professional reasons only.
Okay. Well, yeah, that's a lot of legwork. I assume that the material that you were looking at was not electronically searchable.
Some of it is now, and it would have been, it's kind of totally unfair on the people who do it in paper, but now the Edison papers are all searchable. But most stuff is on paper. Most stuff is on crumbling, rotting paper.
Okay. So I'm going to ask you about the dog that didn't bark. So reading your novel about the invention of the telephone, not your novel, you were reading your book.
Look,
Reads
I'm
like
happy
a
if it
novel.
Feels like a novel.
Sorry about that.
A bodice ripper.
Sorry about it. Reading your book about the telephone and about the Bell Telephone Company's patent and Bell's invention. There's not much in there about Bell the man. I mean, there's some. So fill us in. Tell us about Bell the man. I mean, what happened? There's nothing in there that I may have missed some of it, but there's not much. Not much about Bell after this great victory, where they won 4-3 on a knife's edge at the Supreme Court. Tell us about Bell.
So that's my kind of Rosencrantz and Guildenstern are dead strategy, right? If you move the main protagonist off stage and focus on the lawyers, then you can see what they get done. Bell comes in at a couple of moments, but mainly to
Was that he
argue
would
with the issues.
overshadow the lawyer story that you wanted to focus on? Is that what?
No, because I think the story about what people think are the bit players is actually the real story. Not to say I prefer Rosencrantz and Guildenstern, but that would be a tough fight to pick.
Kill the bearer.
Plus,
of
there are
this
a lot of
message.
great books about Bell already, but it's a conscious decision to sort of move him into the background to show how the lawyers.
Well,
and
you
the
did very
patent
well at
cases-
that.
Thank you. Kind of make the Bell myth, because he's not entirely in control of this. And if you read his letters, at the Library of Congress, you can see all the ways in which he doesn't feel in control of his own story. Right? He's very nervous about how the cases will come out. He feels like he's in the hands of the lawyers. Every time he tries to intervene on the business side, it's terrible. He's a very bad businessman, and people sideline him, and he feels bad about that. He engages in all kinds of anxiety eating and other behaviors. There are a couple of ways in which who Bell was does really matter to the story, and they're actually both about his day job before he invented the telephone, which was being a teacher of the deaf. So one of those ways is that everyone else who was trying to invent the telephone, invent acoustic telegraphs, develop this field, they all came from electricity. They're all people who were experts in electricity, experts in telegraphs, and approach things from that point of view. Bell started with sound and acoustics and knew a lot about that, and then thought about how he could apply electricity to that. So that may have given him, at the very least, an outsider perspective, or maybe also an edge in coming up with what he came up with first. The other way in which his job mattered and his speech work mattered is that he had a pupil in Boston in the mid-1870s called Mabel Hubbard.
He married his work.
He married his work, exactly. So
Me too.
he fell in love with her. She was sort of one of his older students, that's fine. But her father was
I should hope so.
Gardner Hubbard, who was one of the country's leading opponents of the Western Union monopoly. So Bell at some point mentions to Gardner Hubbard, maybe to impress him, given the thing with the daughter, I've got this idea for a new kind of telegraph that'd be real kind of trouble for Western Union. And then Hubbard becomes the biggest investor in the early Bell Telephone Company, the creator of the early Bell Telephone Company, maybe pushed Bell to work on his invention when Bell otherwise wouldn't have wanted to be doing that. So the love story, which is, has been very well treated by Hollywood, does play into that. And of course it's sort of bittersweet because the thing for which Bell became legendary, the telephone, was something that his wife could never use, being deaf. She never used his great invention. And after the telephone, he wasn't an Edison character. He's not a sort of ruthless inventor for life, an irresistible genius. He sort of got involved in many worthy things, moved up to Canada, had inventions in the phonograph, early flying machines. Can't get much more sort of worthy and dignified than that. So I'm very sympathetic to Bell the man. He's very likable.
Yeah, it sounds like he may be more likable than Edison and some of the others. There's always a love story. You know the great love story about the invention, not the invention, but the motivation of Morse to get involved with the telegraph. My students have heard this, so they're going to have to cover their ears here.
There's a sad love story and a happy love story.
Well, the sad one is the one I'm talking about.
Yeah.
With the death of his wife, Morse being maybe the most famous portrait painter of his age, really plugged in, was in Washington painting famous people's portraits, and he got news that his wife had died 8 days or more before in Boston, and he, obviously was unable to even get back before the funeral, and so he dedicated the rest of his life to pursuing faster, more reliable ways of communication. So there is this, there's always a love story.
There's always a love story. That's true of patent law.
Always. So who knew that patent law was so sexy? It really is. And so a question that's been sort of nagging me, when you read your book, it's such an epic story. These cases are so momentous. They involve such big characters, and they're so impactful. How is it that has faded away until it's been dusted
Until
off by
now,
you, and now the
hopefully,
motion
yes.
picture comes? But how have we forgotten this epic story? 100 years from, what, 1781?
1790 is the first patent.
1790.
It's
pa-
sexy
first
for about
patent.
1910,
Yeah.
and then we
And then
forgot until
we
about
fizzled.
1982. Yeah.
Why is that?
So that's an interesting question. I think, so since you have mentioned my second book, a big part of my second book is going to be trying to figure out why patent law became boring for a period of time. It's going to be more fun than that. But I think the default state of patent law is to be exciting, right? So for the first century plus, it's incredibly dramatic. There are big fights on the commanding heights of invention and industry. Patent law is argued by generalists and senators and presidents to be half of Abraham Lincoln's cabinet had all done patent cases when they were lawyers. And that's kind of coming back now. So the Supreme Court bar, people like Seth Waxman, do a lot of patent cases because this is hot stuff, bet the company litigation. I think that's really the default state. There's this period in the middle where patent law fades. I think it's got a couple of reasons, both of which are interesting to me. One is the specialization. So patent law for much of the 20th century was a thing for patent lawyers. Technically trained lawyers operating somewhat as a remove from other branches of the bar. Anytime you get something that's kind of specialized and siloed in that way, I think there'll be a tendency to dismiss it, especially if it's hard and weird in the way that patent law is. And that's breaking down now. That's something I tell all my students in patent law. Patent law is too important to be left to the patent lawyers now, and really it doesn't need to be. It's something that everyone can be interested in. And at the same time, I think this kind of the patent lawyer in the grey flannel suit is also a reaction to what's come before. So all these fights about industry, all these battles to control technologies in the late 19th century, they leave the new rising big businesses feeling like they don't want to get involved in that, right? So big businesses in less competitive industries, they make their industry less competitive, right? They become oligopolies, competing on other grounds. The American economy is very stable in terms of what the big companies are in most of the 20th century. And they push patent law into the background. It doesn't get fought over. But when you get back to having a sort of more dynamic, innovative economy and dynamic invention financing, right, sort of finance capitalism of the kind we had in the 19th century and have today, I think those are the kind of situations in which patent law inevitably thrust itself to the fore. It can't stay boring for long.
It'll be back.
Yeah, it is.
Well, monopoly can be boring. Remember the big surprise when the Princess telephone came around and people suddenly realized it doesn't have to be black with a dial. My students, again, don't even know what I'm talking about. They've never seen it. They've never seen a dial rotary telephone, or probably never used one, even if they've seen it, and they have no idea what I'm talking about with the Princess telephone. They probably think I'm making some politically incorrect sexist remark, but it's an artifact. So the second industrial revolution became preoccupied with monopoly and corruption in a very populist sense toward the end. Give us a sense of how your story and the telephone patent touched and was impacted by populist preoccupation with monopoly and corruption.
Yeah, so as I say, the telephone cases couldn't help but get tied up in the goings-on of the day. Bell was a monopoly. The Bell Company was a monopoly, and it behaved like a monopoly. So they had their particular idea of what the telephone was. It was a tool for business people. It should cost a lot of money. It should be very high quality. And they were going to serve those communities and no one else. So towns above 5,000 people might have a telephone system. The countryside, even a lot of small cities, didn't have telephones, and Bell wasn't interested in providing them.
Let me just interrupt. Don't lose that thought. Lots of examples in histories of the same arrogance and mistake.
Right.
The studio executive who said, "Who the hell wants to hear actors speak?" Or IBM in the 1970s, the top executive of IBM saying, "What do you need? We only need 5 computers in the world, and why people need personal computers in their home? It's a crazy idea."
This is the way the Bell executives talk to each other.
Yeah.
They're all sort of rich people in Boston who had railroad money, and they said, the common man is never going to need a telephone, right? Why do they need a telephone? They walk up the street and talk to their friends. And so a lot of people wanted them, and a lot of people wanted telephones to cost less. And when there were attempts to set up a telephone system for whatever small town you were in the Midwest, Bell would come in, stamp it out of existence. When Indiana tried to regulate telephone rates, the Bell Company in Indiana just said, okay, you've passed a state law regulating rates. You can't have telephones. They just shut down the exchanges, they ripped out the wires, they backed out. So that kind of high-handed behavior made it very clear that although there wasn't only one Bell Company, every telephone that was allowed in America was a Bell telephone, and they behaved like a monopolist. So when this gets to the Supreme Court, they're a much-hated company. And Bell's own lawyer writes to the company and says, this is the most hated patent of American history. That meant that every angle that could be taken to attack the patents was taken by somebody, right? So every potential claimant to have invented it, every pretender, everyone with a plausible or implausible claim would be supported by some financier who wanted to either set up a rival telephone company or get bought out by Bell. So there are all kinds of colorful characters who claim. One guy who claimed to have invented the telephone.
Trolls.
Well, trolls would be if they have a patent. But these are kind of, I know what you call them, charlatans, many of them. Some of whom still have supporters, which I should be careful about. But for example, this one guy who claimed that he'd been fixing his telegraph and he'd fallen in the swamp and heard the croaking of bullfrogs from the next swamp down the road two miles away, and the idea for the telephone had come to him. There are all those people all over the place, one of whom nearly beats Bell in the Supreme Court, which is startling. But corruption is the other angle. To start out with, Bell's opponents just wanted other grounds to survive. They lost all the infringement patent cases, so they wanted to find grounds to another kind of defense or affirmative attack. They persuaded the US government to sue on the grounds that Bell had procured his patent by fraud. They didn't actually have a fraud at the time in mind. They were comfortable with any theory of fraud, but they got the US government to do this because the Attorney General of the time, Augustus Garland, was a shareholder in a rival telephone company. That itself was a scandal.
The plot sickens.
But they may actually have discovered a dark secret about the Bell patent. Bell got his patent issued very fast. There was someone else who'd filed a patent, not by an application, but
Gray.
Elisha Gray had filed this document on the same day as Bell, a caveat, sort of a notice that he was going to file, used to establish priority. And there were various goings on in the patent office where Gray got shunted aside and Bell got his patent.
They put the date on Bell at the time of filing on.
Yeah.
Well, that was unusual, right?
Yeah, Bell's lawyers had the patent application hand-delivered instead of in the mail. Not quite sure why that was. They specifically asked that the time of receipt be written down, which it was, and then later that day, Gray's application comes in. So they knew something. They probably had somebody on Gray's team on their payroll, and they pretty much definitely had the patent examiner on their payroll as well. So the patent examiner who dealt with all this was, very sadly, an alcoholic who was heavily in debt to one of Bell's patent lawyers. It has never quite been shown exactly what dodgy things went on, and there are explanations for these things that and not inconsistent with Bell having gotten the invention first, that he didn't actually transmit any words by telephone until after the patent got issued. But as this got dug into, there was a scandal at the patent office, and then of course there's the scandal of people figure out the Attorney General has 5,000 shares of stock in a rival telephone company, and he authorized this fraud suit. Yeah, he had his deputy authorize the fraud suit, so that's another scandal. And then there's the third scandal when the Supreme Court justice, who'd sat on circuit in an earlier case, is found to have had relatives with hundreds of thousands of dollars of Bell stock in Boston. So this whole thing just blows up. There's a fantastic newspaper headline from, I think, 1886. It just takes up almost the entire front page of the New York World that just says, "Hello, hello, telephone scandal."
Well, it's really a stage, in your words, a stage-worthy drama worthy of Firestone Productions' Kinky Boots or something. It's really quite an amazing story. But it was not just isolated to the Bell system. I mean, this was kind of a problem with a lot of the patent prosecutions, wasn't it?
The corruption? We have to assume so. I mean, it's the Gilded Age because everything was expensive looking but kind of shady.
So, what do you like at home when you're working on one of these projects? To ask it. Oh, yeah. It's Saint Anisha over there.
So, anyone who writes a book, I think, is going to find that it takes over part of their lives. They would rather it not take over. February 14th for me is always the day when Bell and Gray filed their competing patent applications. I struggle to remember.
You don't
that it's
remember your
Valentine's
anniversary,
Day.
but you remember that date.
Well, it's Valentine's Day. You've got to
Easy to remember.
remember that.
Good excuse.
Patent filing day.
Nice recovery.
But yeah, I mean, so what you're like at home depends very much who you're at home with. And Anisha has always been my best and favorite reader, and has been way more interested in this than I have any right to expect all the way through.
Well, I think we can begin to open this up to questions from others in the audience and give other people a shot. But I'm going to, I know you didn't want me to do this, but I'm going to. And just a quick, before, as a transition, while people collect their thoughts, I had a quick lightning round. Okay, and just say the first thing that pops into your mind.
Even since I asked you not to do this, I've taken a lot of cold medication, so this is going to be worse even than I thought.
Can you add some wine to that and get some synergistic effects on that? All right, patent number 174465.
Fraud. No.
Okay, well, there you go.
Bell's great patent.
That's the Bell patent.
That's the Bell
That's the first one, right? Eli Whitney.
Oh. Someone who could never get his patent enforced.
Cyrus
I wanted to
McCormick.
say Scrooge. but-
Screwed, you can say that. I mean, we're all friends here.
Cyrus McCormick?
Yeah.
Brothers. He was the guy who was one of the main inventors of the mechanical reaper. He had this fantastic patent campaign, and it was he who, his lawyers hired Abraham Lincoln for the biggest fee that Abraham Lincoln ever made to work on some tiny part of the reaper case. The most interesting thing about Cyrus McCormick is he had interesting brothers, one of whom was a famous preacher. See, I told you not to do this.
It's great. Mabel.
Mabel, the great love of Bell's life. He always said the best thing he ever did in Boston was not invent the telephone, it was meet Mabel.
Antonio Mucci. Mucci.
The
Antonio
Godfather.
Mucci.
Meucci, yeah. Have you ever seen The Godfather Part 3? Anyone know this? So, Meucci was an Italian-American inventor who claimed he'd invented the telephone when he was a theater designer in Havana in the 1850s. And he would have filed a patent, except he was injured in an explosion on the Staten Island ferry. His claim has been very important to the Italian-American community, and the House of Representatives actually passed a resolution in, I think, 2002, recognizing Meucci's invention of the telephone. Yeah, but he's mentioned in The Godfather. There's a bit where Michael Corleone is approached and told that he's being honored by the Antonio Meucci Association, which which is a real
Inside
thing
joke.
somehow.
Yeah, yeah, real thing.
And he responds with some profanity about the issue.
Chauncey Smith.
He's the lawyer. He's the guy who had the idea. This is the theory we should follow.
If people were describing him, how they would describe him.
So everyone said he looked like Ben Franklin. He was sort of bald on top. In the old-fashioned style, he wears long at the sides and bald on top. He'd wear a frock coat, his big theatrical guy, and it was said of him that he had a twinkle in his eye that could turn to menace in a second. Very good courtroom guy.
Undulatory current. Undulatory current.
That's the basis of the monopoly. So when
The fifth claim.
the fifth claim of Bell's patent basically was the application of this undulatory current to transmitting vocal sounds. And you could have defined what Bell's invention was in all kinds of different ways. You could have said it's this particular machine. You could have said it was this way of using electromagnetism in a particular way. There are other ways of doing it. But the court decided that that theory of the continuous undulatory current was what he'd invented, and that's every telephone. So that's why he controlled every telephone.
Professor of duplicity and quadruplicity.
That's Edison.
How do you get that?
So he had invented a duplex telegraph, which is a way to have two messages on one line at the same time, so you can double your broadband telegraphs, basically, extra capacity. And he promised it to Western Union, but then Jay Gould whispered in his ear, and he sold out to Western Union's rival. And so Western Union's people in the press dubbed him the inventor of the duplex and the professor of duplicity and quadruplicity.
Okay. Last question. What is your favorite footnote in your own book?
The last one that I copy edited, and
Oh, fair enough. Fair enough. I'm sure that was Anisha's favorite footnote as well. Okay, we've got some time for. I'll just wrap this up by saying, this is a phenomenal book to read. I would encourage everybody who hasn't had a chance yet to read it, and also to tell everybody else to read it. You learn so much. It's very thought-provoking, and it's incredibly impressive for the amount of original scholarship and original analysis that you've distilled and put together in such a compelling way in these pages. So thank you very much. We're very proud to have you with us. Okay. Yes, sir.
Hi, I work with Anisha. My name is Jason.
Hi, Jason.
Can you talk a little bit about how the either the patent or monopoly or both lasted so long after the Supreme Court decision? I mean, was the term only 20 years back then, or did he figure out how to make it go longer? And if not, how did he keep the Bell telephone so powerful for the next century?
So the term was 17 years. So the Bell patent ran out in 1893. And in fact, there's then a period where the world of the telephone was totally different. Within 10 years, there's an enormous amount of competition in telephones. People do start these small-town telephone systems, these farmers' telephone systems. And Bell drops to about a half share of the market. And the telephone growth in that period is incredible. So that was something that, again, we forgot when AT&T came back to dominate. But I think, although the patent isn't still in effect, there's a path dependency effect, right? How you start off matters. And because the Bell company had this 14-year head start, had built this nationwide company, had a lot of money and a lot of technological lead over everyone else, they discovered they didn't have the only way of making telephones, and they didn't, in fact, have the way that everybody wanted. But when the rival telephone companies got their foothold, Bell was strong enough just to squeeze them and squeeze them and squeeze them and squeeze them out of existence. Eventually with political help, because state regulation and federal regulation in the 1930s adopted what Bell always wanted to be the model. Bell Company always wanted the model, which was one system, one service, universal service. This is all a story about telecoms regulation, right? So the patent doesn't explain everything. It certainly doesn't explain a century of AT&T, but to the extent that that century depended a lot on where they started, and the patent explains that better than anything else.
Terrific question. Anybody else? Yes, sir.
Yeah.
How would you compare How would you compare the power of the lawyers today to shape the narrative compared to during the Bell case?
It's a great question. So I think lawyers today still have the sort of narrative of individual genius that lawyers had then, right? So it's often commented on that one of the sort of paradigms that floats around in the patent system is the idea that individual invention, one person, a genius ideally, comes up with a great breakthrough and they deserve their patent. And that's an argument you can make to a jury with a lot of currency now as then. Mark Lemley's written a thing called The Myth of the Sole Inventor, where he talks, very nicely cites my work on Bell and other people's work on sort of how many inventions we think are one famous person, in fact, are a whole collective venture. So that's still there. But I think the ideal of the heroic inventor has never been as strong as it was in the 19th century, when people saw the telephone, the electric light, the great inventions revolutionizing their world, and were told there's a particular inventor. So it's height there. And also now, the courts and the law are a bit different, right? So we've got the Federal Circuit, which, for all its alleged faults, and I'd never say a word against them, at least has a bunch of judges that coordinate patent law and sit at the appellate level in unifying it, whereas in the 19th century it's much more of a free-for-all, and the judges will very freely admit, I don't know anything about technology, but Senator so-and-so here has told a great story about this inventor. He's clearly a great inventor, and so I'm going to go with that. There's Supreme Court Justice David Brewer, I think it was, has this great line about, I'm no mechanical expert. And when I looked at the invention, it was barbed wire. So it's two pieces of wire twisted together like that. I thought, wow. So in a lot of cases, you wouldn't have gotten there. I don't think the patent bar is as powerful relative to the bench now as they were then.
Well, before we go on to the next question, talk a little bit about the evolution and the emergence of the patent bar, maybe as the first specialty bar in a country where lawyers were generalists or, you know. Talk a little bit about that and when it happened, how it happened, and who some of the leading figures were.
The two things that were true of almost the entire legal profession in the 19th century were it was localist and it was generalist. But it wasn't specialized and it wasn't national. And the patent law was an early big exception to that. Because of all these great patent campaigns, right, it became necessary and worthwhile to have people who were specialists arguing patent cases in federal court, not necessarily because they were technical. So Governor Seward of New York, Senator Seward, sometimes Secretary of State Seward.
Daniel Webster.
Daniel Webster made some of his, towards the end of his life, he needed or wanted vast quantities of money, and patent law was the way to get it. So Charles Goodyear, people around Goodyear paid Daniel Webster vast amounts of money. And those people would travel around and do patent cases. It became a sort of national thing. The emergence of the patent bar, as in sort of a mass of patent drafting specialists and patent litigating specialists, is a little bit later, but it's still very early. There's this great American Bar Association, one of the early meetings in the 1870s, where the patent lawyers say we should have a special section on patent law. And somebody gets up and says, if you have a section on patent law, pretty soon you're going to want to have a section on insurance law, and then a section on railroad law, and then the bar will be hopelessly balkanized. We could never do that. But they do, and it's the early foothold there.
Great. Who else has a question? Yes, sir.
One of the things you mentioned earlier was patent trolls. And it seems that people today would argue that there are folks using the patent system in a manner for which it wasn't intended to be used. Did you find in your research there was a way then that people were trying to use the patent system which seemed kind of at odds with what the goal might have seemed to be?
Yeah, in fact, broaden that question out, because one of the things that struck me was all the implications of what was going on between 1800 and 1850 that have implications for patent reform legislation today. So.
Yeah, so the patent trolls are a big part of the patent crisis now, the perceived patent crisis. And I think crisis is the natural state of the patent system, because we can accept the rationale that inventors get a reward for their invention. But we've set the patent system up so that the reward flows to the owners of the patents, who may or may not be inventors, may or may not be people who practice the invention. And in some cases, they're going to make vast amounts of money, bring lots of litigation, be very successful. So when the patent system is hot, we can look at entities that are making a lot of money, who don't seem to be themselves contributing to innovation. We can even see from the amount of litigation that it must be suppressing innovation in some way. So those complaints about patent trolls now are continuous all the way back to the 19th century, more often called patent sharks in the late 19th century, but also plenty of nationwide monopolies.
I wore this sharks on my tie with briefcases.
Excellent. So it's a slur, but it's a long-term consistent slur of patent lawyers who wanted to enforce patents on a very large scale. I know you don't mean it that way. It's honorably meant, honorably tied. So yeah, I think that story about patent trolls and the system kind of being a drag on innovation more than a benefit is an old one. Now, what that tells us about patent reform today is kind of an interesting question, right? Because one thing you can say is, in response to the complaint that we're in an unprecedented patent crisis, this is really not unprecedented. There's nothing new under the sun. And in fact,
Ecclesiastes 1:9.
yeah, based on the research I've done more recently, the patent crisis now isn't even particularly big as a patent crisis compared to what happened in the 19th century. There were hundreds and hundreds of cases being filed by individual, call them patent trolls if you want, in 1860, more than any given patent troll is filed in 2013 or 2040, right? So relative to the size of the economy, that's a really much bigger thing. So you can say what's going on now is not unprecedented, and you can say that there's been patent crisis going on at times that have proved to be very innovative times in American history, big technological revolutions.
I mean,
so
isn't it fair to say that the patent law has always been stretched and pressed and torn by dynamic, it applies to a very dynamic, perhaps the most dynamic part of society, which involves economic growth, business change.
Right.
And so I guess like Jefferson says, it's inscribed in the rotunda. What is that quote about?
My eyesight is not good enough to see that far.
Well, it's very big letters. So it's something along the lines of, it would be wrong to make a young boy wear, I'm paraphrasing, wear this, when he's a man, the same jacket that he wore as a boy. And therefore, intellectual property law, patent law has to grow and stretch and change to fit changing times. And so it's really a reflection on the dynamic, I think it is. I mean, you're the expert. I'm just making this up.
Yes. Yeah, I mean, I think the lesson is that it's always adapted. And to the extent that we're talking about now, it means the one thing you shouldn't do is say, patent law is in crisis, something must be done. Here's some legislation, this is something, therefore it must be done. Right? We know a lot about how the patent system, especially through the courts, has adapted as technology has changed, as property rights have ebbed and flowed. It's really a very flexible and it's a system that's adaptable and good at surviving. So I have quite a lot of trust in the patent system to be able to survive as something effective.
And there's self-correcting mechanisms. So one recurring phenomena that was certainly seen was the enormous growth in different periods of the volume. I mean, Jefferson was complaining about it, the judges complained about it. And now that's certainly been the case, at least in the rocket docket in Texas, but that's self-correcting because there's so many cases there that they don't go so fast anymore. So people file elsewhere.
Yes, and there are definitely things about patent litigation now that you can describe as abusive, and I think the courts and Congress together are moving to cut off that sort of thing. But there's also a move, as there always is, by people whose ox is gored by the patent system, people who don't want to have to pay out for the big inventions. They would be interested in seeing more weakening of the patent system. But I don't think that's going to, the lesson is that doesn't happen very often. The patent system comes close several times to being seriously weakened. There's even an abolition movement in the 19th century, but that never quite takes off.
Talk a little bit about the competing values in the judiciary when they approach a patent question. So at the end of the Industrial Revolution, when the telephone case, well, in the middle of it, when the second Industrial Revolution, when the telephone cases were decided, on one hand, wanting to promote business and innovation and reward creators. On the other hand, a distrust and opposition to monopoly. On one hand, a devaluation and an unwillingness to give strong patent rights to merely evolutionary inventions, you know, favoring jerks over creeps, as you put it.
Right. I should probably clarify. That's
That's
term
from a biological
yeah,
that you
so
picked up. But
evolutionary schools have thought about whether evolution is very continuous or has sort of big leaps. They call it creeps versus jerks, and so I lifted a bit of that language.
and I'm going to be stealing it forever now. I like it.
Yeah, everyone's one or the other, right? So those balances in the patent system, monopoly on one side, fear of monopoly against reward to the inventor, they've always been there and still there to this day. The interesting thing, I guess, about the patent system is that it doesn't have an official mandate to regulate competition. Right? It's not antitrust. The patent system has never been supposed to deal with industrial structure or pick winners and losers. It's meant to be sort of about the calculus of, have you invented something, have you disclosed it, have you applied for the patent, do you get it? So that's the exercise that judges are going through in their mind, but really always they've been thinking about monopoly as against reward to the inventor, two sort of very strong values that go into the patent system. And so historically, when you look at these things, part of the challenge is, when are they doing something they don't say they're doing? Right? Why do these three Supreme Court justices think Daniel Drawbaugh invented the telephone? Well, the best argument, most plausible one to me, is that really they had qualms about the Bell monopoly, and so they're trying to knock out the patent. As antitrust comes along in the 20th century, of course, that's something that really reshapes patent law from the outside. That's a big part of, I think, what I'm going to start researching next about the New Deal and the role of antitrust in bending patent law in various ways.
Something to look forward to. Any other? I think we have. Liz, how are we doing on time? How are we doing on time?
We can let people direct.
Okay.
Yeah.
Well, is there one more question that somebody has? Oh, yeah, sure. Janet. Janet Cinder.
I'm just wondering what you think about why patent terms have not increased the way that copyright terms have increased.
So the picture I always use for my students is two sides. Copyright is a snowball rolling down a hill, getting bigger and bigger and bigger, longer terms, more rights involved, more things covered, because of the collective action problem. Right? There are the creators who are well organized, and there are the consumers of copyrighted goods who are generally the people out there who don't have anything like the same legislative muscle. Patent law is the pendulum in the other picture, which swings back and forth, because at any given time, you've got some powerful businesses who are inventing things and like strong patents, and some powerful businesses who are consumers of invention who don't like being held up by patents. And that keeps the whole thing in some sort of balance. And it's swung back and forth. Sometimes patent rights have been very strong, sometimes they've been weak. Now they're back to being pretty strong again. But it's got more sort of central inertia than copyright has. That's my best guess.
Well, what a feast. And let's turn to a real tangible meal and with some drinks, and have an opportunity to talk to Professor Beecham about his book in person, one-on-one. Thank you very, very much.
Thank you, everybody.